Thank you for joining us at the Illinois Department of Labor for this presentation on the Paid Leave for All Workers Act, What Employers Should Know. Here's some background about the new Paid Leave for All Workers Act, which does take effect January 1st, 2024. The General Assembly finds that it is in the public policy interests of the state for all working Illinoisans to have some paid leave from work to maintain their health and well-being, to care for their families, or to use for any other reason of the working person's choosing. And Illinois is one of only 3 states with a paid leave for any reason law. I want to stop here and point out that this is not a sick leave law. This is not a law that is only for when an employee has a doctor's appointment or is sick or has a family member who's sick. The leave that this act requires is to be used for any reason of the employee's choosing. And the law says that the provisions of this act shall be liberally construed in favor of providing workers with the greatest amount of paid time off from work and employment security. Best practices for compliance. This presentation is intended to offer general guidance on the provisions of the Paid Leave for All Workers Act. The Department of Labor cannot provide legal advice, and employers should consult their own legal counsel to determine what actions they should or should not take in order to comply with the law, including any situation specific to their business or operations. Okay, go ahead.
Thank you. So just to provide an overview of what we're going to cover today, we're going to start off with who is covered. Think of employees, employers, like the definitions that matter. We'll go through some key terms, such as how paid leave is provided, whether that be front loading or compare that to accrual. We'll also discuss uses of paid leave in context. We'll go over certain employer responsibilities. We'll discuss at the end penalties enforcement and throughout, and at the end we'll also discuss our frequently asked questions, which you can find at our website, which is labor.illinois.gov. First off, because we know that in certain local municipalities or towns, cities, there is an overlap with local ordinances. The law applies to any employer who does not already have a qualifying pre-existing policy and who isn't already covered by a local paid leave or paid sick leave ordinance in effect on January 1, 2024 that meets the minimum standards in the Paid Leave for All Workers Act. Questions regarding the Chicago ordinance should be directed to the City of Chicago Office of Labor Standards, which is chicago.gov/labor standards. Questions regarding the Cook County paid leave ordinance should be directed to the Cook County Commission on Human Rights, and that can be found at at cookcountyill.gov.
Okay, so some main takeaways that we want to highlight at the beginning of this presentation, and we will be covering them in more detail, but these are some important things to know. Number one, any employer who has a bona fide pre-existing policy that allows all employees to take 40 hours of paid leave for any reason of the employee's choosing is not required to modify the terms of their policy. Number two, employers may enact reasonable, clearly communicated policies that establish circumstances in which the employer may deny an employee's request to use paid leave due to operational necessity. Employees should know where they stand and be able to plan ahead. So now we'll discuss who is covered by the Paid Leave for All Workers Act. So again, I want to cover something I just mentioned, which is pre-existing leave programs. What if an employer has an existing policy such as paid time off, paid sick leave, or paid vacation? Do we have to modify or change that program? Put another way, do we have to comply with the new law? Are we covered by this law? So If you have a bona fide policy that meets the minimum amount of paid leave set forth in Section 15A of the Act, which is 40 hours, and your employees can, in fact, take that amount of leave for any reason each year, you do not need to modify the terms of your pre-existing policy. So please note that a sick leave policy would likely not count for this provision because sick leave is usually limited to use for certain reasons, such as an illness or a doctor's appointment. This leave must be for any reason of the employee's choosing. Also, it must apply to all of your employees. If your current policy excludes part-time employees or new hires in their first year from getting any paid leave, that policy likely would not qualify for this provision. And some guidance from us: if you believe that your current plan complies with this provision, you are advised to communicate this clearly to your employees and to maintain documentation supporting this compliance. Back to you.
So let's start off with some important definitions. For example, what is the definition of an employee under the Act? Which translated another way is who is covered on the Act. And so for the purposes of this particular law, employee has the same meaning as a definition of employee in Section 1 and 2 of the Illinois Wage Payment and Collection Act, with some additional categories, which means that part-time, temporary, and seasonal workers are covered. All domestic workers, for example, nannies and housekeepers that fit under the definition of domestic work, are covered. Employees of state and local government agencies also covered. Interns, however, that's if they are considered employees under the Act. An important caveat: who's not covered? We look to the independent contractor test to determine whether or not a particular employee or a particular worker or someone at your job site is covered under the independent contractor test, which means according to the Illinois Wage Payment Collection Act, employee includes any worker who performs work for an employer unless that worker is a bona fide independent contractor, which means we would look at three factors. One, are they free from control and direction over the performance of their work? Two, do they perform work which is either outside the usual course of business or is performed outside all of the places of business of the employer, unless the employer is in the business of contracting with third parties for the placement of employees? And three, they're in an independently established trade, occupation, profession, or business. And we added that emphasis. That's not the emphasis in the actual law. So these three factors indicate for us whether a worker is truly an independent contractor or is an employee covered under the Paid Leave for All Workers Act. Now, what about union employees? Many who were considering whether or not they are covered by the law, we look to collective bargaining agreements. So if you're covered under a collective bargaining agreement that's in effect on January 1, 2024, or let's call it grandfathered in for the duration of that agreement. So if a union agreement is in effect now and it goes beyond 2024, that union contract would cover that period of time until that expiration date comes up. So a little caveat there: union, construction, and freight employees are not covered at all. And we'll discuss that on the next slide. Second bullet: after January 1st, 2024, parties subject to CBA may waive the Act in new contract or contract renewals. But it's only waived if that provision is explicit, clear, and unambiguous in that new CBA or the extension of the existing CBA. It must be explicit and specific to waive it. For example, a CBA signed July 1st, 2020, expires on June 30, 2024. Parties will need to address a possible waiver when they negotiate a new CBA on or before July 1st, 2024. If there's no waiver agreed to and added to that contract an extension, the employer must comply with the law, which means Paid Leave Act for all would apply for that period of time starting on the date when the expiration was up, although the parties may want to bargain over individual provisions of the employer's policy. Just a best practice guidance from January 1, 2024 and after, consider inserting language in any collective bargaining agreements regarding the Paid Leave for All Workers Act, whether or not you're waiving it or not. Different provisions apply for state agency employers and employees, which we recommend consult your human resources office or your union. Let's also talk about some employee exceptions. Some groups of employees are specifically exempted from the Act, which means certain railroad and airline employees, certain higher education employees, including but not limited to college university students who are employed part-time by their school with some conditions, or some short-term temporary employees of institutions of higher education with some conditions. CBA, collective bargaining, covered union construction work. Let me slow down there. CBA covered construction work, and the final bullet, CBA covered, aka union, package, transportation, and delivery work, which would mean domestic and international freight. We can go to the next slide. Finally, let's get to the definition of employer. Under the Act in Section 10, employer has the same application and meaning as provided in Section 1 and Section 2 of the Wage Payment Collection Act, except for purposes of this Act. Let's slow down. Employer also means state and units of local government, comma, any political subdivision of the state, or units of local government, or any state or local government agency. We put that emphasis in bold for you to think about. Employer, however, does not include school districts organized under the school code or park districts organized under the park district code. We put that in bold because we get a lot of questions here. Recommended that if you have questions, the plain language of the law is the best place to begin with your questions. Now, under the IWPCA, which is Wage Payment Collection Act, in Section 2, employer shall include individual, partnership, association, corporation, LLC, business trust, comma, employment and labor placement agencies, staffing agencies, where wage payments are made directly or indirectly by the agency or business for work undertaken by employees under hire to a third-party consultant, contract between the business or agency with a third party, any person who or group of persons acting directly or indirectly in the interest of an employee in relationship to an employee for which one or more persons is gainfully employed. I'm sorry that was a mouthful, but we just wanted to put an emphasis. Employer also includes employment and labor placement agencies covered under the Act. So that's a really busy slide. If you have questions about it, start with the law and then send any questions you have to us. Next slide.
Okay, so now I'm going to cover a few of some frequently asked questions we get on these topics. So first, may municipalities or counties opt out of the Act in order to provide fewer hours of paid leave than what is required under statute? And the answer is no. The department recognizes that Section 15P of the Act provides an exemption for municipalities or counties with a local ordinance in effect prior to the effective date of the Act, if that ordinance requires employers to provide any form of paid leave, including sick leave. However, Section 5A of the Act sets the statewide minimum standard for the amount of paid leave that employers, including municipalities or county employers, are required to provide for their employees. And that statewide minimum standard is 40 hours. Any local ordinance that is enacted or amended after the effective date of the Act, which is January 1st, 2024, must comply with all Paid Leave for All Workers Act requirements. So given the potential legal implications of such local laws, ordinances, or regulations, it's recommended that employers consult with legal counsel prior to changing or enacting such policies, laws, rules, or regulations. A couple of other frequently asked questions that we receive. Number one, does this apply to remote employees? And does this apply to employees who live in Illinois but commute to Indiana for work every day, or vice versa? Essentially, how does this law apply to people who may or may not work in Illinois, or for a company located in Illinois? How does it work? So we have traditionally found that Illinois workplace protections apply to employees who primarily perform work in Illinois for a company that does business in Illinois. And because there is a number of possible configurations of remote work arrangements, such as 100% remote, mostly in office with some flexibility to work from home, hybrid schedules, workers who are traveling nearly continually for work, we can't offer a one-size-fits-all answer, but in rulemaking, we have tried to provide guidance on some factors to consider when evaluating your employees' work arrangements. So now we'll go to the section on provision and use of paid leave. We are going to use the terms accrual versus front-loading, which are the two different ways employers can choose to provide leave. So in the accrual method, employees earn 1 hour of paid leave for every 40 hours worked. The employer would keep track of how much time each employee has actually worked and give them 1 hour of paid leave for every 40 hours worked. Employees can accrue up to 40 hours per year, meaning the employer can cap accrual at 40 hours for each 12-month period. Please note, a part-time, temporary, or seasonal worker is entitled to earn paid leave under the Act, but because they work less, they might never actually accrue a full 40 hours of leave in 1 year. So, for example, an employee who works 10 hours a week earns 1 hour of paid leave every 4 weeks. Let's say they work 50 weeks per year. They're going to earn about 12 hours per year. So those part-time employees are not exempt, but they might not accrue the full 40 hours. And regarding front-loading paid leave, instead of requiring employees to accrue leave gradually throughout the year, employers can choose to make 40 hours of paid leave, or a prorated amount for part-time employees, available to the employee at the beginning of the 12-month period. This is called front-loading. Please note, the 12-month period is not necessarily January to December, and it's up to the employer to determine. So it could be each individual employee's anniversary date. It could be your fiscal year that starts in July. That's up to the employer to choose and document. And if the employer changes that 12-month period, they must provide detailed written notice to employees in advance. Please note, front-loaded benefits may not be retroactively diminished, which means that if you front-load paid leave to one of your employees and they quit before the end of the year, or they end up reducing their schedule, you cannot make them repay any front-loaded benefits. Now, between front-loading and accruing, the employer will find there's going to be pros and cons for either method for your situation and your preferences, and it's up to the employer to design a plan that will work for them in their workplace. So here are some frequently asked questions. Can we front-load less than 40 hours for part-time workers? Can we prorate front-loaded paid leave for employees who are hired mid-year? Can we match our paid leave 12-month period to our fiscal year, which starts July? Can we use an employee's hire anniversary date to set their 12-month period? And the answer to all of these is yes, and they're all sort of related and based on the same principle, which is that the employer can design a front-loaded leave plan to be prorated according to their business practice, so long as the amount of leave provided is 1 hour of paid leave for every 40 hours worked, which means employers can front-load paid leave for part-time employees at a prorated amount consistent with that employee's anticipated work schedule, but employers must add paid leave time if the employee ends up working more than they expected. And if an employer sets a January to December 12-month period, for example, and hires an employee who starts in July, the employer can front load 6 months worth of paid leave when they start in July until the following January. That employee would start a fresh new year just like everybody else. And for an employer who, let's say, wants to follow a July to June fiscal year, coming up January 1st, 2024, the employer can count January 1st through June 30th, as 2024, as half a year, provide leave on a prorated basis for that 6 months, and then start fresh with a new 12-month period on the first day of your fiscal year, July 1st. Some other questions. Can we front load 40 hours for full-time employees and have our accrual for part-time employees? Yes, you can have separate policies that provide paid leave via front loading for some employees and via accrual for others, but those policies must be applied consistently, communicated ahead of time, outlined clearly in your written policy, and not illegally discriminatory. Can an employer who front loads hours recoup paid leave an employee has used if the employee's employment ends before the end of the year? Answer, no. The law does not allow an employer to make an employee repay paid leave time that was front loaded at the beginning of the 12-month period. Benefits that have already been provided may not be retroactively diminished. This also applies if you front load paid leave according to an anticipated work schedule. If that employee ends up working less than you expected, you cannot take back or make them repay their used or unused paid leave. Okay, back to you.
Thank you. So now let's talk about overtime exempt employees, managers, professionals. Some salaried staff work far more than 40 hours a week. So how does earning paid leave work for them? Generally, under the Fair Labor Standards Act, administrative, executive, and professional employees who do not get overtime under the Fair Labor Standards Act, their earning rate would cap at 40 hours per week. So you would set up your accrual so that they earn 40 hours a week rather than an actual accrual per hour worked. Generally, employees that meet that exemption accrue 1 hour per week, even if they work more. For example, a manager at a retail location, if that manager is Fair Labor Standards exempt management who works more than 40 hours a week, the manager would be deemed to work 40 hours per week for purposes of accrual under the Act. Pro tip or a guidance, carefully review the Fair Labor Standards Act definition for administrative, executive, and professional employees. A big question here, when can employees use paid leave? Starting in January 1st. So paid leave, the law goes into effect January 1, 2024. Paid leave shall begin to accrue or be front-loaded on January 1, 2024, or if they start after that, when they start employment, for employees hired after that date. Employees shall be entitled to use paid leave 90 days after January 1, 2024, or 90 days after they start employment. For employees hired after that date. Bullet point, 90-day waiting period only applies once for any given employee for the duration of their employment. It's either January 1st for the current employees or upon hire for future employees. Let's talk about rate of pay, which is a term of art. Section 15F is discussed in the law, defines and discusses rate of pay. Employees shall be paid the regular rate of pay for time taken on paid leave. For practitioners in this area, that specific reference to regular rate of pay is something you should focus in on. Tipped employees shall be paid at least the minimum wage in the jurisdiction where they work. What about an employee leave request? So employers must allow for oral or a written request to use earned paid leave. Section 15H in the Act, employers can, but it's more of a but. Under Section 15H, employers can have a reasonable paid leave notification policy, which means under H1, if there is a foreseeable leave, employers can require 7 days notice. Under H2, if it's unforeseeable, they should provide notice as soon as practical. Pro tip or guidance here, this area requires employers to carefully consider operational needs and the term reasonable and foreseeability in light of the right of employees to take time off for any reason. So, an employee request for paid leave. An employee may choose whether to use paid leave provided under this act prior to using any other leave provided by the employer or state law. For example, if you've got vacation leave, personal leave, paid time off, some other leave, paid or unpaid, an employee may choose whether to use paid leave provided under this act prior to using any other leave provided by the employer or state law. See section 15E, the act. Now, what about a denial of paid leave? Which some have pointed out, wait, it's for any reason. Are there circumstances where an employer can deny paid leave? Let's slow down here. Employers may enact reasonable, clearly communicated policies that establish circumstances in which the employer may deny an employee's request to use paid leave due to operational necessity. I believe we've also addressed this in rule, but it's important to highlight. Must be in the employer's written employee handbook and distributed to all employees. So slow down and consider that. We highly recommend you put it in your, well, there's a must. It must be in the handbook and it must be distributed to all employees.
Okay, so the question as to whether paid leave carries over is one that we get frequently, and the answer is it depends on how the employer designs their policy. So it depends on if the employer decides to provide paid leave via accrual or via front loading. So generally under the Act, an employee's unused paid leave that was provided via accrual shall carry over annually. However, front-loaded leave does not have to carry over. And this goes to the point I made earlier that there are pros and cons for either arrangement that the employer is going to have to consider for themselves and design a policy that works. Please note the employee is entitled to use 40 hours each year unless the employer chooses to allow them to use more. So now a couple of frequently asked questions. Can we deny an employee's request to use paid leave under the Paid Leave for All Workers Act? Can employers set times of the year, such as holidays or peak production periods, that when use of paid leave is limited? And what about firefighters or other emergency responders? Can we restrict the use of paid leave? The answer is generally yes. An employer may adopt a reasonable policy that establishes some parameters for taking leave and limited reasons the employer may deny leave for operational necessity. Any such policy must be reasonable, communicated to employees in that written manual that everyone gets, applied equally to all employees, and must conform with other applicable state and federal laws. What about no-call, no-shows? So an employer can adopt a reasonable policy regarding how they will handle no-call, no-show absences, but employers cannot require the employee to disclose the cause for the absence. More questions. Can employers force employees to use this paid leave time if their employees request unpaid leave or another form of paid leave? Or can I require my employees to take sick time before taking paid leave time, or vice versa? And the answer is no. The law says that an employee may choose whether to use paid leave provided under this Act prior to using any other leave provided by the employer or state law. If you, as the employer, have another paid leave policy or unpaid leave policy or practice, the worker can choose whether to use paid leave before that. And how does this interact with FMLA? So that's a different story. FMLA is a federal law, and employees going on FMLA leave may use paid leave time concurrently during their FMLA leave. Please note, we at the Illinois Department of Labor do not administer or enforce FMLA, which, like I said, is a federal law. So all FMLA questions should be directed to the U.S. Department of Labor. Couple more questions. Because employees may carry over 40 hours per year and use can be limited to 40 hours, can employees bank leave and carry it over forever? So we've proposed rules to clarify this point, but the Act itself does not specifically address this topic. Employers can limit use to 40, and even part-time employees who may not accrue a full 40 hours each year are entitled to use up to 40 hours if they carry some over. Can I make my employees take leave half a day or a day at a time? So unless you have a bona fide pre-existing policy that qualifies for that provision we mentioned at the beginning of the presentation, where if you have a pre-existing policy that qualifies, you don't need to change any terms. If you do need to comply with all the terms of the Act, then the highest minimum you can set for using leave is 2 hours. So let me give a couple of examples to explain this. So let's say you have an employee who wants to take 45 minutes of paid leave to run an errand. An employer may have a policy requiring them to use 2 hours. Now let's say you have an employee who wants to take 3 hours of paid leave. The employer may not require them to take 4 or 8 hours instead. So let's talk about payout. I know this is a common question, and it's a nuanced topic. This Act, the Paid Leave for All Workers Act, does not require payout of unused leave provided under this Act unless the leave is credited to the employee's general PTO bank or employee vacation account, meaning if you have a vacation plan already and you add to it or you combine this paid leave with your vacation bank, you should be aware of your obligations under the Illinois Wage Payment and Collection Act, which does require vacation payout upon resignation, termination, retirement, separation. Take a look at the Wage Payment and Collection Act Section 5, as well as the administrative rules under the Illinois Wage Payment and Collection Act. So review both of these laws carefully, consult an attorney, as you think about compliance solutions for your paid leave policy or policies. Okay, back to you.
So let's transition and go over just a few more employer responsibilities before we wrap up. What about pre-existing paid time off or vacation plans? Employer who has a bona fide pre-existing policy that allows all employees to take 40 hours of paid leave for any reason is not required to add or change their plan. Nothing in the Act shall be construed to discourage employers from adopting or retaining paid sick leave, paid vacation, paid holidays, or any other paid time or paid leave policy more generous than the policies that comply with the requirements of the Act. Basically, what we're saying here is you're feel free to exceed the minimum bar set in the law, which just the law requires time off for any reason. But you can also have a different type of paid sick leave in addition to regular paid leave. You can have paid time off, vacation. You can have other benefit programs for purposes of serving your employees and maintaining compliance. Records requirements. Great question, because what do we have to do to ensure compliance? And this is what we haven't said throughout, which is the goal of this presentation is to give employers information to help them maintain compliance, which is our goal throughout. Section 20 covers related employer responsibilities, which requires employers to keep records of each employee's hours worked, hours of paid leave accrued or provided, and front-loaded, and hours of paid leave used, and when. That record retention has a requirement of 3 years. Under the law, employers shall provide IDOL access to the records. There will be a public notice, which is like a Know Your Rights poster, a required poster that will be placed on our website for all employers. You can download it, print it, and post it. And employers of domestic workers have special provisions that apply to them, given that the work is often in the home. So see the Act and consult counsel if you employ domestic workers. Regarding the employee handbook, employers are advised to develop an employee handbook, personnel policy that clearly communicates any policies they want employees to abide by. Any such policies must comply with the Paid Leave for All Workers Act and any other applicable laws. The handbook must be in writing and distributed to all employees on or before the employee's first day. For some, that means it could be distributed via an application that employees have access to it, but the word in writing and distributed is what's important here. In absence of a written handbook, the department will still conduct an investigation of whether an employer has unlawfully denied an employee their rights under the Act.
Okay, so now to cover the anti-retaliation provisions of the law, which are in Section 25 of the Act. The law says employers shall not consider an employee's use of paid leave as a negative factor in any employment action that involves evaluations, promotion, discipline, or counting paid leave under a no-fault attendance policy. So in other words, in addition to simply not retaliating or taking adverse action against someone, such as firing or demoting them for using paid leave under this Act, please note, if an employer has a points-based attendance system that leads to discipline for absences, any instance when an employee is utilizing paid leave provided under this Act may not be counted against that employee. And as a reminder, retaliation is prohibited under this Act. So now I'll go over penalties and enforcement. So complaints can be filed up to 3 years after the alleged violation. An employee whose rights are violated under the Act may be entitled to back wages, compensatory damages, a penalty of $500 to $1,000, or other relief as appropriate. And there may be a penalty payable to the Department of Labor for $2,500 for any violation of the Act except the public notice violation, which is that poster, Know Your Rights poster. The failure to provide and post that Know Your Rights poster may subject an employer to a $500 penalty for the first offense and $1,000 for subsequent offenses. Back to you.
Main takeaways. We're about to wrap up, so let's just recap what we've done and provide some, reinforce what we've learned. And any employer who has a bona fide pre-existing policy that allows all employees to take 40 hours of paid leave for any reason of the employee's choosing is not required to modify the terms of that existing policy. Employers who are subject to the law, the Paid Leave for All Workers Act, may enact reasonable, clearly communicated policies that establish circumstances which the employer may deny an employer's request to use paid leave due to operational necessity. Employees should know where they stand and be able to plan ahead. Finally, IDOL, Department of Labor, will be emphasizing employer compliance assistance for the first part of 2024. I'll restate that. The goal is to get everyone into compliance. In the first part of 2024, however, we will review every complaint to determine whether it warrants an investigation starting on January 1, 2024. Now, for more information And, as an outgrowth of this process of providing information to the public, we need you to help us populate our frequently asked questions. We last updated them December 5th, 2023. We've got proposed rules to clarify provisions of the Act. IDOL, our agency, recommends employers and employees review our website for FAQs. If you see something in there that you're just not sure about, feel free to email us. Not like we'll get back right away, but we read every email and we try to populate the FAQs based on how frequent they are in a priority order. The required notice will be posted in required posters section of the website before January 1, 2024. And feel free to visit our website at labor.illinois.gov/FAQs/paid leave FAQ.html, or just Google it and you'll find your way there.
And when you get to our website, just some visual aids here, labor.illinois.gov. On the home page, if you look down where there's a big arrow, you'll see a button that says paid leave information. If you click that, it'll take you to this page where you will see our email address where you can ask questions, which is dol.paidleave@illinois.gov, a link to the law itself, which you can click and read, proposed rules, which you can also click and read through, and eventually adopted rules will be linked there when those are finalized, and the frequently asked questions link, as well as dates and times and registration links for future webinars. So to recap, thank you for joining us today. We hope this has been helpful. If you have further questions, you can email dol.paidleave@illinois.gov. There may be questions for which it is advised that you consult an attorney who's able to give you specialized legal advice for your specific situation. But if you have general questions about the law or the rules, you can send those to dol.paidleave@illinois.gov. And of course, find us at labor.illinois.gov. Thank you so much for joining us today.